His bidding proved successful. With respect to the Girard Point project, he got a $70 million contract. Whoa, that's a big contract. The DOT defines that term, socially and economically disadvantaged, primarily on the basis of race and sex. Oh, wait, you can't discriminate on the basis of race and sex. It's strange. And then the law says, oh, actually, you have to discriminate on the basis of race and sex. Don't give it to white dudes. No paints for white dudes. Put the roller down. DEI scammers get crushed by the Supreme Court. We're going to go through this one in the case of Gouveia versus the United States. This is a situation where some people said that they were small disadvantaged businesses and they got these contracts from the government saying, we're going to go and be diverse in our sourcing of our business endeavors. Turns out they were liars. That didn't work out so well for them. They got charged with crimes. They took this case all the way up to the Supreme Court, and Judge Amy Coney Barrett is the judge who is delivering the opinion on the court. And we've seen some interesting takes from her over recent decisions from the Supreme Court, but this one just came down. It's an older case that was actually argued some time ago, but just decided this past week. And Justice Barrett, Amy Coney, delivers the decision. Here's the background on the DEI scammers. All right, we got Stamateos Kasousis and the industrial painting company called Alpha Painting. So we've got Stammy and Alpha. And what we've got here is a business that got 2 government contracts in Philadelphia, right? So take us back to Pennsylvania, Philadelphia. We've got this person called Gouveia and Alpha Painting. They got a contract. Both contracts required the participation of a disadvantaged business. You probably have heard of this. Small disadvantaged business, women-owned business, whatever, LGBTQ plus business, whatever. So you have to go and work with these disadvantaged businesses. And they would place bids. They would get money from the Pennsylvania Department of Transportation. But the promise that they said turned out to be an empty one. In addition to using the suppliers that was solely as a pass-through entity, they also, the scammers, submitted multiple false certifications to cover up their scheme. So although Alpha and their paint work met expectations, they weren't actually employing disadvantaged people, whatever that means. So they got busted. The government charged them with wire fraud. They said, wait a minute, you said you were going to give this to disadvantaged people, but this was fraud. You got painting contracts and you didn't employ any of those people. So there's a theory called fraudulent inducement theory, where a defendant commits federal fraud when there's a material misstatement that tricks somebody into giving you a contract, regardless of whether the fraudster caused a net loss. All right, so the defense here from the scammers will say, well, so what if we didn't use the small disadvantaged business? It was irrelevant. It had nothing to do with the services that we're providing. Like, we didn't go hire LGBTQ painters, but so what? We gave you a great deal because we hired some straight white guys or something or whatever. I don't know what they were doing, but it wasn't small disadvantage. So, but it wasn't a net loss to you. Like, you guys weren't harmed at all. So who cares? So the Supreme Court came back down and they said, well, we have to ask ourselves, does there need to be a net loss? Does there have to be some sort of penalty, or just the fact that there was a fraud that occurred? Is that enough? They say it is. If you're saying you're going to use small disadvantaged businesses, then you got to do it. When 2 Philadelphia landmarks, the Girard Point Bridge, so our friends over in Philly, you might know what these places are, Girard Point Bridge and the 30th Street Station, they fell into disrepair. Pennsylvania Department of Transportation went to go get bids to restore these. So this guy, Gouveia, and the Alpha Paint Company, they submitted a bid for the project. Wow, they're big monies too. His bidding proved successful. With respect to the Girard Point project, he got a $70 million contract. Whoa, that's a big contract, to a joint venture comprising Alpha and 2 other companies. The 30th Street project, Alpha and another company also got a $15 million contract, and that was nearly a third of the $50 million, right? So we're talking big money, not like we're going to go paint a bedroom. Federal grants for the U.S. Department of Transportation was a large amount of that money. So the U.S. DOT, like, we're all paying for this, right? So we're going, okay, you guys take this money. As a result, both the federal and the state government had to say, well, if you're going to paint $70 million worth of stuff, we don't want that many white dudes painting it. All right. So, well, especially if they're straight. So make sure they're not getting their work. Okay. Like, okay, fine. So relevant here, transportation requires that grant recipients like Penn establish and actively implement a disadvantaged business program. A disadvantaged business, according to the DOT, is a for-profit small business that is majority owned and controlled by one or more individuals who are both socially and economically disadvantaged. And we don't even know what that means. Because the DOT aspires to have at least 10% of federal grant funding to disadvantaged businesses, it's an important part of this conversation. Now, consistent with this rule, the Department of Transportation required that the bidders for these 2 projects in Philly commit to subcontracting a percentage of the total contract amount, which would be 6 to 7%, to a disadvantaged business. Failing to comply with this requirement would be a material breach. You can't do that. Accordingly, Secondly, as part of the bidding process, Coussis and Alpha, the paint companies, you got to give $6.4 million to this other company called Marqueas, and that's going to be a pre-qualified disadvantaged business, right? So like, okay, yeah, we'll give it to Marqueas over there. Marqueas was a lie. As later memorialized in a commitment letter, Alpha and Coussis concocted a scheme in which Marqueas, this other company, would function as a mere pass-through entity. They have no disadvantaged people over there? The scheme operated as follows, right? Oh yeah, we're going to give everybody lots of disadvantaged businesses. Coussis arranged for Alpha's actual paint suppliers, with whom he negotiated directly, to generate purchase orders that were billed to this other company. So they probably like, oh, well, Hunter knows how to set up shell companies. So we'll just set up a shell company and we'll say that's a disadvantaged business, and then they can buy the paint and we'll just funnel it through them. When Marqueas got an invoice, it tacked on a few percent fee and then forwarded the inflated invoice to the main company. He then issued two checks. He would pay one back to the company for its markup and then the other to the actual cost of the supplies, right? So Marqueas was no more than a paper pusher. He was funneling checks and invoices, and it was just a fake scam. Not only did this arrangement contradict the prior representations, it also contravened the rule. You must perform a commercially useful function in your small disadvantaged business. So the scheme initially went undetected. As projects progressed, he reported, oh yeah, no, we're getting qualified payments. They're like, are you giving this to a small disadvantaged business? Like, yeah, totally. Look, here's the receipts for it. It's all right here. The Pennsylvania Department of Transportation, satisfied with the paint and repair work, they paid it. They're like, yeah, great job. Everything got painted. By the time the last coat of paint had dried, Alpha made $20 million, and Marqueas, for its pass-through services, had pocketed 170 grand. But once the deception came to light, a grand jury indicted the company and the dude for wire fraud and conspiracy to commit the same. After a trial, the jury found them guilty, 3 counts of wire fraud, but they moved for a judgment of acquittal. They said, you can't prosecute us. We didn't do anything wrong. Our paint work met the expectations. So what if we didn't give that to small disadvantaged businesses? There was nothing harmed you. Penn DOT had received full economic benefits of the bargain. Like, in other words, we complied with the contract, and the lack of a small disadvantaged business participation didn't matter at all. You guys weren't defrauded of anything. There was no money or property that you lost as a result of us just reorienting this money. Now, the lower level court rejected the argument. Court of Appeals affirmed, said, nah, sorry, you guys are guilty. As both courts explained, obtaining the government's money was precisely the object of the scheme. Like, the fact that they got the money, that's enough. It doesn't have to do with the work. The scheme targeted the money because the agency paid for services that they thought were going to come from disadvantaged people, and that didn't happen. So that paint sucks now. The circuits are divided over the validity of a fraud conviction when there was no actual intent of pecuniary loss, like financial harm. Several circuits have said no, the conviction may stand. Like, the fraud doesn't have to result in an actual financial harm. We granted cert to resolve this split to figure this out. If you're going to be charged with wire fraud and these other crimes, do you actually have to have caused a financial harm to the other people, or could just the receipt of that money be enough for the fraudulent inducement and enough to charge a person with? Now, to convict, the Supreme Court, Amy Coney Barrett writes, to convict Alpha and Coussis, the government needed to prove the following: that they used the wires to execute a fraud with false representations. Now, despite the use of the disjunctive or, okay, like or, they're going through the statute, you can execute a scheme or artifice to defraud or for obtaining money. She says, well, we've declined to interpret that of establishing alternative pathways to a conviction. Instead, we read those two clauses together, and we have held that the money or property requirement operates as a limitation on the former, right? So this is the thing with statutes, right? Statutory construction, it can be very confusing, and different courts can have different interpretations of a literal word, right? Or, like, what does that mean? They say, well, it's actually not like you can do this or you can do this. It's this with the limitation of this. It's not two separate independent clauses. One's actually acting as a limitation on the prior clause. A defendant commits federal wire fraud, in other words, they're going to explain, only if he did all this, both engaged in deception and had money or property as an object of the fraud. This is how they've interpreted it before. So the money or property requirement lies at the heart of the dispute. Although the lower courts once interpreted the phrase money or property as something of a catch-all, Supreme Court says we recently reiterated that the federal fraud statutes only reach traditional property interests. Schemes that target the exercise of the government's regulatory power don't count. Got to have some financial component to it, nor do schemes that seek to deprive another of an intangible interest that is not connected to property, right? That provision of the law doesn't apply to these other cases. Now, in all cases, because money or property must be an object of the fraud, the traditional property interest at issue must play more than some bit or part in a scheme. It's got to be the aim. It can't just be incidental. And so from all of these rules, the defendants here, Alpha and the fraudsters, they attempt to glean another. They say, okay, look, if you combine all these things, like it's not as simple as there was just a fraud. It's got to be a fraud plus this, and this, and they were not harmed, so it doesn't meet the elements. But the theory under which they move cannot stand. They say a federal fraud, their argument, cannot stand, they argue, unless they sought to hurt the bottom line. Like we had to actually intend to defraud you in a way that was harmful to you. But the theory under which they're prosecuted, what they call the fraudulent inducement theory, doesn't actually require economic loss. Both parties describe it. The theory suggests anytime you use falsehoods to induce a victim to enter into a transaction, that's good enough. In these situations, the defendant need not, given the reciprocal nature of most transaction, does not aim to inflict economic loss. And because Alpha and Cousisis did not intend to do that, they say their convictions are invalid. Like, we didn't intend to actually harm them. Okay, that doesn't matter. That's not the requirement, says Amy Coney Barrett. We're not convinced. The fraudulent inducement theory is consistent with the wire fraud statute and our prior precedent. And so there doesn't actually have to be an economic loss in order for there to be a fraud. Look at the facts of this case, she says. By using Marcaius, which is that third party like shell company, as a pass-through entity, they devised a scheme to obtain a contract. They said, oh yeah, we're going to get disadvantaged businesses in here. They got tens of millions of dollars. And how did they do that? By making a number of false and fraudulent representations. They said, yeah, well, we're going to buy our paint from this disadvantaged business. And they didn't do that. And so they met the statute. The statute requires nothing more. Their contrary view rests on the premise that a scheme cannot be wire fraud unless there's more harm. But that's not what the statute says. It says to obtain otherwise, something means to gain or possess. She looks up the dictionary. She says, an art collector who acquires a rare sculpture can rightfully say that she obtained it, if she stole it, I guess, and because of the meaning obtained doesn't return on the value, an art collector can say whatever they want because the art price is dynamic. Now, in short, the wire fraud statute is agnostic about economic loss, and the statute doesn't even mention it, doesn't require it, and so a conviction here comports with the law. Now, regardless, cases involving deceit are inopposite from the question presented here. So let's summarize, she tells us. Common law courts did not uniformly condition an action sounding in fraud on the ability of related to loss. More specifically, if the action was one for rescission or a prosecution for false pretenses, the required injury ordinarily did not need to be financial, and that's the death knell for these defendants. The old soil principle does not apply. We don't have to go to the old rules if we have a new rule that's perfect for us here. And we do. It's all here. Even Alpha and Cousisis concede that common law did not require economic loss. So they're like, well, even if we go back far enough, it's not exactly in our favor. And there is none. After all, animal horse, sound horse, going through another case is what she's doing. Now, they contend that the fraudulent inducement theory is at odds with other aspects of our precedent, but she says, no, they're not. They're perfectly in sync, and we're not undermining our prior case law. They also warn that the consequences of this, if we set this as a rule, there's going to be a lot of problems here. They say under this theory, if this is the rule, every intentional misrepresentation designed to induce someone could be a property fraud. And they say, no, that materiality requirement narrows the universe of actionable misrepresentations. So this is not going to create some big problem where everybody, I was frauded, I was defrauded, and everybody's going to be prosecuted. No, it's got to be a material fraud. So it's got to be like what you did, like tens of millions of dollars coming into your coffers when you said you were going to move it one way or another. So because the Third Circuit's judgment is in alignment with the law, we affirm it. It is so ordered by Amy Coney Barrett. Now, Justice Clarence Thomas is also coming in a concurrence on this. So he is joining with the majority. Says the court correctly rejects the request to add in, right, to write into the law some new economic loss requirement. He says, no, it doesn't require that. And so I join the opinion in full. But I also want to talk about this material thing. When the government prosecutes a defendant for wire fraud, we have to talk about materiality. Because they have not contested that their misrepresentations were material, we're not going to pass on that issue, but I am skeptical that their misrepresentations were material. Oh, interesting. So Clarence Thomas is saying, well, yeah, he's like, so what if they didn't use small disadvantaged businesses? All right, that's fine. He says the statute doesn't require economic loss, so they're properly prosecuted here. But the materiality component of this that they are kind of hanging their hat on, like as a protection that this won't turn into a big thing, he says, I'm not so sure this actually was material. He says they entered into a contract to repair the bridge. The contract purpose was paint the bridge. The bridge got painted. Requiring it to go to small disadvantaged businesses who are whatever percentage, that's not part of the contract. The purpose of the contract was to paint the bridge. To achieve these goals, what they need to do? Paint the bridge. Structural steel repairs, roadway constructions, miscellaneous government projects, and more. Clarence Thomas writing, the contracts for these two jobs totaled more than 1,000 pages and numerous regulatory, technical, political and ethical obligations and all this crap. Among other things, the agreements required these fraudsters to abide by the Workmen's Compensation Act, buy American provisions, use steel, generally avoid using convicts as labor, and also not to discriminate. Oh, look at this, right? So they say, wait, Clarence Thomas probably has a better argument here. Well, they have to also follow the law. And there's other Workmen's Compensation Acts, and they can't discriminate on the basis of race, color, national origin, or sex. So the small disadvantaged business, what is this? The contract's also required to apply with the DBE program, the Disadvantaged Business Enterprise, saying that was established in 1983. It sets a goal that at least 10% of federal funds be expended with small business concerns owned and controlled by economically disadvantaged individuals, which is 51% owned by somebody who is economically disadvantaged, whatever that means. The DOT defines that term, socially and economically disadvantaged, primarily on the basis of race and sex. Oh, yeah, and the other law says, wait, you can't discriminate on the basis of race and sex. It's strange. And then the law says, oh, actually, you have to discriminate on the basis of race and sex. Don't give it to white dudes. No paints for white dudes. Put the roller down. The program rebuttably presumes that any member of certain enumerated races that have been subjected to racial or ethnic prejudice or cultural bias within the American society is a member of that group because of his or her identity. Wow, that's very gendered language in our statutes. Wow, what if you're non-binary? Says among groups presumptively eligible, look at this. Black Americans, you get an extra handout. You get a quota provision from our government. Our government said don't be racist or judge people on their skin color, race, or ethnicity, like Civil Rights Act, Martin Luther King, all that stuff. But then special carve out for Black Americans, Hispanic Americans, Native Americans, Asian Pacific Americans, and subcontinent Asian Americans. So the Asians are also a problem too. White guys, not small disadvantaged at all, no matter what happened in their lives or whatever their experience was in the world. They're fine. The crack epidemic or reverse racism or affirmative action or whatever is not disadvantaging white people at all, or especially white dudes, and also not certain Asians. You have to be a subcontinent Asian American, or you have to be Asian Pacific American. I don't know what the other ones are. So it's curious. Now, the DBE program also provides this favorable presumption to women, not dudes. DBE certifiers may not question claims of group membership as a matter of course. So if you're like, hey, it's interesting, I'm starting to think this should be a small disadvantaged business show. You know what I'm saying? Maybe we can get $70 million or something. We're small disadvantaged. You're a white dude. Nuh-uh. Section 26.67A3 says you may not question the claims of our membership in a matter of a group. Okay, so it's like insane. It's ridiculous. Thus, in practice, being certified as a minority certification to get presumptive status, writes Clarence Thomas, as the owner of a disadvantaged business operates on the honor code, as the information is rarely verified. And how could you verify that? You'd actually have to check their ethnicity. You kind of look black, but I'm not positive on this. Are you like that one woman who was running in the NAACP, who's not really black, but she says she was black? There's a whole documentary on it. Who's going to verify that? Yeah, okay, you look pretty white, but I guess if you say so. While those excluded from the DOT's list of presumptively disadvantaged groups may attempt to prove sufficient disadvantage, the application process is a high hurdle. For example, here you go. A white male claiming to have experienced employment discrimination must submit a declaration about personal narrative, providing evidence that his status or limited opportunities to earn income from specific prejudicial acts were directed at him because his distinguishing feature is being a white dude. Yeah. But you may attempt to prove, but they're excluded. Interesting. Okay, so you can prove it if you're a white guy, but good luck. So the DOT incorporated the goals into both contracts in this case, even though the other law says don't discriminate against anybody. But in this case, it's allowed because it's just white dudes. So as the majority explains, petitioners are misrepresented their compliance with those provisions. That's true, but the government prosecuted them, saying that was fraud. The jury convicted them, and they got 6 years in prison for that. Now, although the court leaves the question of materiality for another day, we need to talk about it here. Materiality is an element of the government, and they must satisfy that. Now, the government says the standard for materiality here is articulated in another case law, and he says, okay, it has to go to the essence of the bargain. Okay, the essence of the bargain is not about using non-white males to paint the bridge. It's about painting the bridge. That's the contract. The government doesn't need to get involved in this crap where they're saying, okay, only black people from this location or only subcontinent Asians from this location. That's not the bargain. That's not the essence of what's happening here. We need a bridge painted. Paint the bridge, get a roller. I don't care what color your skin is, get the job done. I seriously doubt that the DBE provisions can meet this standard because that's not the essence of the bargain. Saying, Clarence Thomas writes, we rejected other limitations in this other case, and we talked about materiality. Even in the face of a contrary contract, materiality cannot be found where there's minor or insubstantial non-compliance. A party's actions may reveal that a contract term is not material. If the government regularly pays a particular type of claim in full, despite actual knowledge that other minor things have happened, we've allowed that to happen. Applying these familiar and rigorous principles, this is not automatically material. They got to prove that this is a real problem. Now, the court reserved the question on this for another case, but the standard we articulated is going to raise this into question. He says, let's talk about this case specifically. Clarence Thomas writes, the contracts in this case were for bridge repairs. The contracts were not to go hire minorities. There are several reasons. This is a black man writing, okay? So don't get mad at me. There are several reasons to think that the DBE provisions did not go to the very essence of the bargain. First, the DBE provisions were irrelevant to the contract's fundamental purpose, which is bridge repair, which suggests that they were the sort of minor or insubstantial conditions that were not material at all. As the Third Circuit also recognized, although petitioners did not meet their conditions, they did a good job. They delivered the requested work. The quality of the workmanships and the materials were all uncontested. If the DBE conditions the disadvantaged business, if they went to the very essence of the bargain, the failure to meet those conditions would have impacted the final work product. But the final work product, which was the bridge being repaired, was not. The conditions here had no bearing on their ability to complete their project. That disconnect tends to support the conclusion that those requirements were not material to the performance of the contract, and so therefore they can't be criminally charged. Second, the DBE provisions appear to have been less important in the contract terms than the actual repair. Like, do you want the bridge to be done, or do you just want minorities painting things? Like, what do you want? What is the primary purpose of the contract? It's to paint the bridge, says Clarence Thomas. 10%, 6% of the others was going to minority or disadvantaged individuals, but that's not the crux of the claim here. The contract required the DOT to deduct payments due to their work if the job was done unsatisfactorily. While the contracts labeled the failure to comply a material breach, they said that that may result in termination, so it's not automatic. As explained in other cases, we've said that there needs to be more. But if the fraud is so prevalent that the government would have to assume a significant number of contractors violate the provisions, that again would say cast doubt on the materiality. There's a lot of reports of fraud in the DBE program. There's no exception here. Fraudulent DBE schemes where minority and women contractors are used as false fronts is an area with serious enforcement and compliance problems. Legislators have recognized this problem. Looking at this from the viewpoint of the prior law, this program could suggest that a reasonable contractor could follow the contract language and actually believe that DBE was not essential. It's like a recommendation. Yes, we'll try, but you want us to get the job done, right? So if we can't go find these things, would you rather us not paint it with white people, I guess, with non-disadvantaged people, or not? And we've completed the contract, which was the end game. If complying with the provisions would violate the law, it's also difficult to see how representing the compliance would be a wrong inducement. Clarence Thomas raps, he says, I am skeptical that the government could meet this bar and that these guys could be convicted. While the government has not been put to the test in this case, it appears to have elsewhere endorsed the program's race-based benefits on the ground that minorities represent more than 20% of the population, but they only 9% of all construction firms, and they receive only about 5% of construction receipts. So I guess our government then has to correct the marketplace and make more minorities own businesses. Maybe they don't want to. Maybe that's not their profession. Maybe they got other industries, but the government says we're going to correct this. But proving a broad sociological proposition by statistics is dubious business, says Clarence Thomas. And at least one court has said that the DBE policies are in fact discriminatory. He's also saying it's also implausible to think that a reasonable person would attach importance to contract provisions that mandate constitutional violations. Here we go. If the government cannot demonstrate that the DBE program, which requires you to categorize people by race and ethnicity, literally they wrote it down in the list, subcontinent Asians are only allowed. I doubt that it's constitutional. I doubt that a provision requiring compliance with an unconstitutional program that chops people up based on race, that is not reasonable to comply with that. At bottom, says Clarence Thomas, the essence of the bargain standard is rigorous and it's context specific. The bargain was the bridge. Although the contracts in this case are riddled with DBE crap, we have made clear that the materiality inquiry turns on substance rather than labels, and that focus may doom these prosecutions if there is a material problem. Now, in persuading the court to reject the economic loss arguments, the government has assured us that, yeah, the essence of the bargain standard for materiality will ensure that you're not going to just start prosecuting all these people. But the materiality standard was not met here, and saying saying lower courts should hold the government to its word. Interesting case there, and I think Clarence Thomas is probably the closest to being right on that. Obviously, we don't want anybody defrauding the government. If you're going to say you're going to do something, we want you to do those things. But in this case, they were asking them to comply with stuff that is clearly unconstitutional. And we have the now trading card game where they're treating people like trading cards, like, hey, you get one of these, you get one of these because you're a black company over here. We've got a gay company over here. We've got a women company over here. But all the white dudes, you're not disadvantaged at all. Just shut up. And that whole scheme should be subject to strict scrutiny. We're classifying people based on gender and race and ethnicity and ideology and maybe religion if you're disadvantaged or whatever. And so it is something that should be looked at with a lot of scrutiny from our courts when they mandate those things as part of government contracts. We don't want our government coming into the markets and trying to create justice. They're terrible at it. They're morons. They don't know what they're doing, and they pervert everything from getting done. We'd rather have the government just say, here's a contract for business. The best people who paint the bridge, the best painters can get it done for the best price and deliver a product, not deliver social justice and bureaucratic manipulations in our markets. They're not good at that. Clarence Thomas knows it better than anybody. And so an interesting decision here. The convictions essentially affirmed for these two. So they'll be serving their time, and we'll see if the Supreme Court continues to develop this area of law. Obviously, we got Gorsuch, Sotomayor, and Clarence Thomas, who are not entirely on board with the majority. And there's a question of materiality. So a good decision from SCOTUS. As always, we'll keep our eye on what's happening in that docket. Thanks for subscribing and joining as we do.